I am calling 19 CF20 State versus Jake Patterson. Mr. Patterson appears in person and with attorneys Richard Jones and Charles Glynn, the state by District Attorney Brian Wright, Assistant District Attorney Boyle, and it's my understanding is that District Attorney Mark Freuhoff from Douglas County? Freuhoff, okay. Mr. Wright, I was informed yesterday there may be a plea agreement. Is that true?
It is true, Your Honor, and I'm prepared to recite that for the record.
If you would, please.
The plea agreement is that Mr. Patterson will plead guilty to counts 1, 2, and 3 as charged in the information. Count 4 will be dismissed and read in. Additionally, the state will not file criminal charges against Mr. Patterson for crimes committed in Douglas County that are connected to the course of conduct giving rise to the Barron County charges. This is set forth in more detail in a letter dated March 26, 2019 from Douglas County District Attorney Mark Freuhoff to Mr. Patterson's attorneys. The state is requesting the court order the Department of Corrections to conduct a pre-sentence investigation and prepare a report on this investigation. Both sides will be free to argue at Mr. Patterson's sentencing hearing. Finally, the state, as to Barron County and Douglas County, is in compliance with victim notification as provided in Section 950.04 Sub 1V, Sub G of the Wisconsin statutes.
Mr. Freuhoff, is that true as to the Douglas County charges?
Yes, it is.
Okay. And Mr. Jones, is that your understanding of the plea agreement?
Your Honor, that is our understanding of the plea agreement. And at this time, we're going to tender to the court a plea questionnaire and waiver of rights form. And also to that document is an attachment that outlines the elements and the offer. There's a plea agreement listed, the charges and penalties, and the elements of each of the offenses to which Mr. Patterson is going to plead guilty are also included, if I may approach.
Yes, if you would, please. Mr. Patterson, and if you put the microphone in front of him, Mr. Jones, thank you. Mr. Patterson, is that your understanding of the plea agreement?
Yes.
Mr. Patterson, I have in front of me a plea questionnaire and waiver of rights form. Do you see what I'm holding up, sir?
Yeah.
It also has attachments including the plea agreement and the elements of the offenses. Do you see what I'm holding up?
Yes.
On page 2, it appears to have your signature. Is this your signature?
Yes.
By signing this form, did you wish to indicate to the court that you've gone through the entire 2-page document and attachments with your lawyers, you understand it, and wish to enter into this plea agreement?
Yes.
Did anyone make any threats or promises to get you to sign this form or to plead guilty?
No.
Anything outside of this plea agreement?
No.
Are you satisfied with the work that your lawyers have performed for you so far?
Yes.
And either Mr. Glynn or Mr. Jones, are you satisfied that Mr. Patterson's pleas today are knowingly, intelligently, and voluntarily given?
Your Honor, I probably will make a little bit longer record on this comment than normally.
Yes.
We are satisfied that this is free, knowing, and voluntary. Mr. Patterson has wanted to enter a plea from the day we met him, and we needed to really consider our own due diligence. We needed to read all the discovery. We needed to go through the materials. And we will say for the record, and Mr. Patterson is aware, that we don't even have all of the discovery yet. And that's not to say we don't have what we need. There are a lot of materials that are related to the search that is still coming in, but is not relevant to what we need to do here. We have all the police reports surrounding the events at the home. We have all the police reports surrounding the rescue of Jamie. We have all of the police reports surrounding, statements and interviews that we need to do what we need to do. And we have read that. We've watched hours and hours of videos There's something in terms of videos. There's something like 800 gigabytes of video surveillance and other materials. So we've read what we need to read. We've talked to Jake about options, including a court trial, a jury trial. We've talked to him about motions, change of venue, substitution of judge, the opportunity to attempt to suppress his statement, Miranda Goodchild motions. We've talked about potential NGI issues, motions in limine. We've discussed all that with him, and he's rejected all of that and decided that this is what he's wanted to do. He's been consistent with that from the time that we've met. So we have gone through all the materials with him. We discussed them in detail with him, and he has always been consistent in his statements and his belief that this is exactly what he wants to do. So it is free, knowing, and voluntary, especially since from the very beginning, we've gone back and forth with him about what we suggested that he do, or at least give us time to do. But this is his choice. We represent him. We work for him. And this is what he wants. And this is what we're going to do with him. So it is free, knowing, and voluntary.
Mr. Patterson, or Mr. Klinko.
Your Honor, I would just add that I would concur in what Mr. Jones put on the record. It is my signature that is affixed to page 2 of the document. I signed it after reviewing it in the presence of Mr. Jones, an investigator, and Mr. Patterson. And I believe that his plea today is intelligently entered, freely entered, and knowingly entered.
All right, thank you. Mr. Patterson, is what your attorneys told me accurate?
Yeah. Yes.
Mr. Patterson, how old are you today?
21.
And how far have you gone in school?
12 years.
You've graduated from high school?
Yes.
Do you read and understand the English language?
Yes.
Have you been able to read and understand all the documents provided to you in this case?
Yes.
You understand the charges to which you will be pleading guilty?
Yes.
Are you currently receiving any treatment for a mental illness or disorder?
No.
Do you suffer from any chemical dependency issue?
No.
Have you had any alcohol, drugs, or medication in the past 24 hours?
No.
And do you want to go ahead today?
Yeah. Yes.
Mr. Patterson, do you understand that by pleading guilty, you give up your right to a trial?
Yes.
You understand that by pleading guilty, you give up your right to remain silent, and that silence could not be used against you at trial?
Yes.
You understand that by pleading guilty, you give up your right to testify and present evidence at trial?
Yes.
You understand that by pleading guilty, you give up your right to use subpoenas to require witnesses to come to court and testify on your behalf?
Yes.
You understand that by pleading guilty, you give up your right to a jury trial. That's where all 12 jurors would have to agree that you're either guilty or not guilty.
Yes.
You understand that by pleading guilty, you give up your right to confront. That means to see your accusers in court and have them cross-examined by your lawyer.
Yes.
You understand that by pleading guilty, you give up your right to make the state, meaning the district attorney, prove you guilty beyond a reasonable doubt.
Yes.
It's not your burden to prove your innocence, it's the state's burden to prove you guilty. Do you understand that?
Yes.
Knowing that you have all these rights, do you still choose to plead guilty?
Yes.
You understand that the court's not bound by any plea agreement or any recommendation by any pre-sentence or by any lawyer?
Yes.
If I felt justice required, I could impose the maximum penalties consecutive on each charge. Do you understand that?
Yes.
You understand that the maximum penalty for counts 1 and 2 of the information is life imprisonment?
Yes.
You also understand that if convicted today, the least amount of time you could get is 20 years on that. Do you understand that?
Yes.
You also understand that it could be somewhere larger than 20 years. It could be life itself. Do you understand that?
Yes.
You also understand that on count 3, the maximum penalty is 40 years.
Yes.
You understand that if the court felt justice required, I could impose 2 life sentences consecutively with a 40-year sentence consecutive.
Yes.
Knowing that, do you still choose to plead guilty?
Yes.
Regarding first-degree intentional homicide, at trial, the state would have to prove beyond a reasonable doubt the following 2 elements. First, that you caused the death of another person. Cause means that your act was a substantial factor in producing the death. And second, that you acted with intent to kill that person. Intent to kill means that you had the mental purpose to take the life of another human being, or you were aware that your conduct was practically certain to cause the death of another human being. Do you understand that?
Yes.
And you realize they'd have to prove that for both counts 1 and 2 beyond a reasonable doubt.
Yeah.
Is that the crime to which you're pleading guilty on those 2 counts?
Yes.
Regarding the kidnapping charge, the state would have to prove beyond a reasonable doubt the following 4 things. First, that you transported the victim from one place to another. Second, that you transported the victim without her consent. Third, that you transported the victim from one place to another forcibly. And fourth, that you transported the victim from one place to another with intent that the victim be secretly confined or imprisoned. Is that the crime to which you're pleading guilty on the kidnapping charge?
Yeah. Yes.
Yes? Do you understand that if you're not a citizen of the United States, your plea could result in deportation, the exclusion of admission to this country, or denial of naturalization under federal law?
Yeah.
You understand that by being convicted of a felony today, you may not vote in this state as long as you're under supervision of the Department of Corrections.
Yes.
In fact, with a life sentence, if you're convicted, you may never vote. Do you understand that?
Yes.
You understand by being convicted of a felony today, it is unlawful for you to possess a firearm.
Yes.
Knowing that, you still choose to plead guilty.
Yes.
You understand that by being convicted of a violent felony, you may not possess body armor.
Yes.
Knowing that, you still choose to plead guilty.
Yes.
Are there any questions you have of this court regarding your plea or
No.
your rights?
No.
Mr. Patterson, I now pull out the information. Do you have a copy there, Mr. Jones, that he may follow along? Mr. Patterson, your lawyer has given you a copy of the information. That's the charging document in this case. You are charged in count 1 as follows: that on or about Monday, October 15, 2018, in Barron County, you did cause the death of James M. CLOSS with intent to kill that person, contrary to Section 940.01, Sub 1, Sub A, and 939.50, Sub 3, Sub A of the Wisconsin statutes, a Class A felony, and upon conviction shall be sentenced to imprisonment of life. How do you plead to that charge?
Guilty.
Count 2 charges as follows: on or about Monday, October 15, 2018, in Barron County, Wisconsin, you did cause the death of Denise J. CLOSS with intent to kill that person, contrary to Section 940.01, Sub 1, Sub A, and 939.50, Sub 3, Sub A of the Wisconsin statutes, a Class A felony, and upon conviction shall be sentenced to imprisonment for life. How do you plead to that charge?
Guilty.
And count 3. You are charged with on or about October 15, 2018, in Barron County, Wisconsin, by force or threat of imminent force, did carry JLC from one place to another without that person's consent and with intent to cause the victim to be secretly confined, contrary to Section 940.31, Sub 1, Sub A, and 939.50, Sub 3, Sub C of the Wisconsin statutes, a Class C felony, and upon conviction may be fined not more than $100,000 or imprisoned not more than 40 years or both. How do you plead to that charge?
Take a deep breath. One deep breath.
Guilty.
Have you read the complaint in this case at some time?
Yes.
Is it substantially true as it relates to those 3 crimes?
Yes. Yes.
Yes? Okay. And Mr. Jones, are you satisfied that the criminal complaint forms a factual basis for which this court may accept a plea?
I am, Your Honor.
Mr. Jones, is there anything you believe I've overlooked in the plea colloquy?
I do not.
And Mr. Wright, is there anything you believe the court has overlooked in the plea colloquy?
No, Your Honor.
Based upon the plea questionnaire and based upon today's hearing, the court finds that the 3 pleas are knowingly, intelligently, and voluntarily given. I find that there is a factual basis to accept the pleas and find Mr. Patterson guilty of counts 1, 2, and 3. Pursuant to the plea agreement, I'll dismiss and read in count 4. I'm scheduling this for sentencing on Friday, May 24 at 1:30. Will that work then, Mr. Jones?
Yes, it will.
And Mr. Wright, will that work for the state?
Yes, Your Honor.
And I'll schedule that for all afternoon. I'm revoking bond. Anything else, Mr. Wright?
No, Your Honor.
And Mr. Jones or Mr. Glynn?
No, Your Honor.
All right, we're adjourned.
Your Honor, may I briefly, did you approve the order for the pre-sentence investigation report?
Yes, I'll order a pre-sentence, yes.
Thank you.
I'm sorry.